This House will come to order. This House will come to order. Members will please take your seats. Members will please take your seats. Madam Doorkeeper.
Mr. Speaker, the President, President Pro Tem, the Majority Leader, and the Minority Leader of the Senate await entrance to the House chamber.
Madam Doorkeeper, please allow the President Pro Tem, the Majority Leader, and the Minority Leader of the State Senate to enter the House chamber, and please escort them to their seats. It is, yeah. Madam Doorkeeper.
Mr. Speaker, the Honorable Harold Milton, Chief Justice of the Supreme Court, and the Honorable David Namias, Presiding Justice of the Supreme Court, await entrance to the House chamber.
Madam Doorkeeper, please allow the Honorable Harold Milton, Chief Justice of the Supreme Court, and the Honorable David Namias, Presiding Justice of the Supreme Court, access to the chamber. Members may be seated. Members of the House of Representatives and Senate, this joint session will now come to order. The clerk will read a resolution.
House Resolution 315 by Representative Burns, the 159th, calling a joint session of the House of Representatives and the Senate for the purpose of hearing a message from the Chief Justice of the Supreme Court, inviting each other justice of the Supreme Court and each judge of the Court of Appeals to be present at the joint session and for other purposes.
Ladies and gentlemen of the House and the Senate, it is my distinct honor today to introduce to you a dear friend and a distinguished jurist, the Chief Justice of the state of Georgia. A native of Washington, D.C., our Chief Justice grew up in East Point and Marietta. He attended Auburn University, where he was elected to serve as president of the Student Senate. If you visit the campus there today, I'd encourage you to visit the Student Center, which has fittingly been named in his honor by his alma mater. He earned his law degree from the University of Georgia in 1991. He spent 11 years with the Department of Law, where he dealt with issues from the creation of the Georgia Lottery Commission to tobacco settlement. He later served as executive counsel to Governor Sonny Perdue before his appointment to the Supreme Court in 2005, where he has served with distinction ever since. It is for all these reasons that I was honored earlier this session to join with the Speaker Pro Tem of this House, the Majority Leader, and the Minority Leader, and several chairmen to sponsor House Resolution 332, honoring Chief Justice Melton on the grand occasion of his forthcoming retirement after 30 years of service to our state. So please join with me and his dear wife Kimberly as we thank him for his service and welcome him to our House chamber. Ladies and gentlemen, the Chief Justice of the state of Georgia, the Honorable Harold Melton. Let me see if I can slide by you here.
Thank you. Thank you very much. Thank you. Thank you so much. Lieutenant Governor Duncan, Speaker Ralston, President Pro Tem Miller, Speaker Pro Tem Jones, members of the General Assembly, constitutional officers, my fellow judges, ladies and gentlemen. Written in big letters above the bench of the Georgia Supreme Court is the Latin phrase, fiat justitia ruit caelum. Translated into English, it means, let justice be done though the heavens may fall. To me, this motto has always meant that we who are judges must do the right thing and uphold the rule of law regardless of politics, the public will, or the consequences. Now I have another take. Given this past year, I believe it also means that justice must prevail even when everything around us is falling apart. Truth and justice for all must remain front and center, even if we find ourselves in a historic time of great political upheaval, racial and social unrest, and a worldwide pandemic that has altered our lives. I thank you for this annual opportunity to report to the General Legislature the state of this judiciary, what the courts have accomplished this past year, and where we are headed. And I thank you for your continued support. I'm also grateful to Governor Kemp for his leadership and help this past year. I want to give a special greeting to my lovely wife, Kimberly, who adjusted her travel plans at the last minute in order to be here for this moment. I'll tell you that this is the kind of support and love that she has consistently extended to me, and I do thank you for being with me here on this special day, and thank you all for recognizing her in a special way. When I stood before you a year ago, I spoke of the pride and hope that I had in our Georgia judicial branch of government going forward in 2020. I did not know that 3 weeks later I would declare a statewide judicial emergency in response to the COVID-19 pandemic that had reached Georgia's borders. I did not know that in coming months, many of us would lose colleagues, friends, and loved ones to this dangerous disease or fall victim to it ourselves. I did not know how hard our courts would have to work to pivot and change in order to uphold justice. But today, ladies and gentlemen, I can report to you that going forward in 2021, the state of our judiciary is sound, solid, and strong. It is not without its challenges, and I particularly want to thank you for your support of this legislative session in helping us to confront some of those challenges. This past year, I've witnessed firsthand that your judges and courts are remarkably resilient, flexible, creative, and committed in their mission to uphold the law and mete out justice fairly and equitably. It has been my honor and one of the highlights of my professional career to work with an amazingly cohesive group of justices, judges, clerks, court administrators, leaders of the state bar, law school deans, public health officials, sheriff's offices, and others who have collaborated and cooperated to keep our courts open and the work of the judiciary on track, all while going the extra distance to ensure that people are safe. Our courts exist to uphold the rule of law. It is what we are. It is who we are. The rule of law is the principle that in our nation and in our state, the law is in charge, not a king, not a dictator, but a body of laws. No one stands above the law, and no one should be treated differently under the law. In a democracy, our laws must be applied equally, whether you are weak or powerful, rich or poor, white or of color, young or old, or of one religion or another. The rule of law is intended to protect the rights of the people and to prevent tyranny. Justice and the rule of law cannot wait on the pandemic. 1 year ago, on March 12, 2020, in an emergency phone call, I told Georgia's judicial leaders that under state law, the chief judge of each judicial circuit had the authority to suspend jury trials and other court proceedings in response to the COVID-19 virus. The next day, Fulton County Superior Court Chief Judge Christopher Brasher became the first to do so. Others around the state soon followed suit. 2 days later, I declared a statewide judicial emergency following the lead of Governor Kemp. The order took effect immediately and was due to expire in 30 days as state law required. At that time, we knew of only one death in Georgia due to COVID-19. The emergency order signed that day required courts to remain open, to address critical or essential functions and give priority to such matters as domestic abuse restraining orders, criminal bond hearings, mental health commitment hearings, and cases where the immediate liberty or safety concern was present. The order suspended a number of judicial deadlines and urged courts to begin using video conferencing where possible as a safer alternative to in-person proceedings. In the ensuing months, new orders followed every 30 days, extending the statewide judicial emergency order. At first, we thought this pandemic would be over in a matter of months and we would go back to normal. I certainly never envisioned that we would still be within its grips 1 year later. With the help of the Administrative Office of the Courts and Director Cynthia Clanton, we have held emergency virtual meetings almost every week with the Judicial Council. The Judicial Council is the policy-making body of the state's judicial branch that is made up of judges representing every class of court in Georgia. In those meetings, we heard questions that needed to be answered, rules and laws that needed to be changed, and steps we needed to take to get the courts fully operational during a pandemic. In a normal year, there are 4 quarterly meetings of the Judicial Council. In this past year, there have been more than 30, and they've been extremely productive. I want to emphasize that from day one of this emergency, Georgia's courts have remained open, and the work of the courts has continued. It looks different. Along the way, I've told judges that if you have to stick a bucket inside the door of the courthouse to accept the filing and instruct that filer to kick that bucket back and forth in order to get things going, then do that. So our courts have not closed. We've adjusted operations, and there are things that we have not been able to do, but our courts have not closed. Our judges have taken an oath to uphold the law, and many will tell you that they go to bed at night worried about how they can push cases towards resolution without endangering the public health of all those who come to our courthouses. You should be proud of the many judges in Georgia in the superior courts, the state courts, the juvenile courts, the magistrate courts, municipal courts, the business court, and the appellate courts, who have stepped up this year to go beyond the normal duties to keep cases moving as much as possible and to keep people safe. In some cases, it has cost them their lives. Our probate court judges have been particularly hit hard by the virus. Probate judges have a host of critically important jobs, including the emergency appointment of guardians and the involuntary hospitalization of incapacitated adults and other dependent individuals. Ensuring care for those who cannot care for themselves cannot wait until the end of a pandemic. Among probate judges we lost this year from COVID-19 are Judge Karen Batten of Brantley County, described by Probate Council President Kelly Walk as a genuinely kind soul. Judge Nancy Stevenson of Dougherty County, a judge who loved and served her community of Albany, a community which loved her back. And Judge John Payne of Chattooga County, a veteran of the U.S. Marines and the former sheriff's deputy, who was elected Chattooga County probate judge at the age of 25 and remained a probate judge for the next 45 years until he was struck down by the coronavirus. We lost my dear friend and colleague, former Chief Justice George Carley, to the virus. Another former Chief Justice, Norman Fletcher, lost his beloved wife, Dot. And Superior Court Judge Horace Johnson of Covington, a bright, shining star that left us way too early, after collapsing only hours after holding a virtual court hearing from his home. And even though he tested positive for COVID-19, Judge Johnson continued doing his sworn duty until the end. In addition to these countless of judges and staff, deputies, prosecutors, and public defenders, lawyers, and others in our court family, many have contracted the virus but survived COVID-19. I know a number of you have suffered similar losses and may have even had the virus yourselves. I want to thank you for still being here and showing up to do the great business of this great state. Thank you. In the first month of the emergency order, the Supreme Court of Georgia, like other courts, canceled courtroom sessions that were scheduled for March of 2020 for oral arguments. But my colleagues and I, thanks to our first-rate IT staff, quickly adapted to the use of Zoom video conferencing technology, as did attorneys who argued before us. And with the exception of March, the state's highest court has not missed a single month of oral arguments. The cases canceled in March were added to the April calendar, and we have continued to stay on track. Our court of 9 justices continues to meet regularly and virtually to decide cases, and the number of opinions we issued remain about the same as in the last 2 years. We issued 265 opinions from April through December in 2020, compared to 261 opinions during those same months in 2019. At the beginning of the emergency, one bright spot was the governor's appointment last March of a new justice, Judge Carla Wong McMillan of the Georgia Court of Appeals, who took the seat of the retired Justice Benham. Justice McMillan is the first Asian American ever appointed to the state's highest court, and she has been a welcome addition. Although the number of cases argued before the court has slowed during the pandemic, the work of the court has increased because of the pandemic. I'm so grateful to my colleagues, Presiding Justice David Namias, former Justice Keith Blackwell, Justice Michael Boggs, Justice Nels Peterson, our Clerk of Court, Ms. T. Barnes, our Chief Deputy Clerk, Ms. Tia Milton, who formed our internal working group to lead our judicial branch through this crisis. Among many changes, we amended the trial court rules, to allow for virtual hearings through video conferencing technology in proceedings that normally require the physical presence of the judge and parties. We also replaced the in-person Georgia bar examination with an online bar exam to avoid having hundreds of people sitting for hours in close quarters. This took enormous effort, and I'm thankful to all those involved. Former Justice Blackwell, Justice Peterson, the Board of Bar Examiners, the Office of Bar Admissions under the leadership of Heidi Fienza, and the deans of all 5 of our law schools. We have successfully administered 2 remote bar exams, one in October and one last month, testing a total of more than 1,800 applicants who now have a path of licensure to practice law. I also want to thank Governor Kemp and his staff who helped us in making some of these changes. The governor responded to us immediately last April by issuing an order that now allows notaries to certify documents remotely rather than in person. From the beginning of this pandemic, our greatest challenge in the judiciary has been jury trials. When people think of the courts and court business, most think of jury trials, the kind of things we see on TV. Indeed, jury trials are the hallmark of our American system of justice, a fundamental constitutional right in a criminal case to be tried by a jury of your peers. Early on, we suspended jury trials due to the number of people involved, the length of the trials, and especially due to the number of citizens needed to be summoned in order to have jury selection. The public health risk to all involved was significant. At that time, we were seeing COVID outbreaks in Georgia and across the nation, where large numbers of people were gathering inside close quarters, such as they do for a jury trial. The decision to open jury trials is different than opening businesses. Unlike when individuals choose whether to visit a store or a gym or a restaurant, when a citizen receives a jury summons, that is not an invitation. It is an order. We compel people to come to court. It has therefore been critical that when we summon jury trials, we did it the right way, with the necessary safeguards in place to protect the public health and safety of the lawyers, the judges, the jurors, the clerks, the bailiffs, the sheriff's deputies, court reporters, witnesses, defendants, parties, and all the many people we require to be present for trial. But we suspended jury trials at a real cost, and we recognized that we could not suspend them indefinitely, even during a pandemic. Unindicted criminal cases have been building, and there are many individuals in jail who have been waiting for more than a year under the presumption of being innocent until proven guilty. In addition to criminal trials, many people are awaiting resolution of weighty civil matters, including cases that involve business disputes and personal injuries and divorces and child custody. In mid-October, I signed an order lifting the suspension of jury trials. Not too long after we reopened jury trials, however, the number of coronavirus cases spiked. And in December, we had to shut down jury trials again. Since then, our courts have been accumulating more cases, been accumulating more cases that are awaiting indictment and trial. The potential backlog in cases is staggering, and we must find a way to reduce the growing pressure. So 1 week ago today, after the number of coronavirus cases sharply declined, I again signed an order authorizing the resumption of jury trials in Georgia. Under this order, before jury trials may resume, courts must have written plans in place to ensure that jury trials can be conducted safely and in conformity with public health guidance. I'm grateful for the leadership of former Fulton County Superior Court Judge Sean LaGrua, now Justice LaGrua, the most recent appointee to the state Supreme Court. She and Chief Judge Russell McClellan of the Forsyth County State Court together have co-chaired the Judicial Council's COVID-19 task force that I appointed last May. Since then, they've been working diligently on the particulars of getting the courts fully and safely operational during and after the pandemic. These two leaders have marshaled the resources of the judges appointed to that task force and divided them into subcommittees to address various issues. They brought in clerks and civil and criminal lawyers, public health experts, and others as advisors. Among them was Dr. Mark Swaincutt of the Fulton County Board of Public Health, who has been an invaluable source of wise counsel. Together, these professionals, all volunteers, have created guidelines on how courts must operate to ensure safety for in-person proceedings, including jury trials. They started with one question: how can we keep everybody safe? The plans that courts must have in place prior to resuming jury trials cover everything from where people park to how they walk into the building, how they line up to go through security, how they ride the elevators and walk through the halls or visit the restrooms. On the day of a trial, the court will look different than it has in the past. Protocols include pre-screening for health risk of all parties, temperature checks, use of masks, social distancing, plexiglass barriers, touch-free evidence technology, constant surface cleaning, and the reconfiguration of courtrooms and jury spaces to ensure social distancing. You may see spectators in one courtroom and participants in another, all so that we can accommodate social distancing. In some cases, court will be held in a different building altogether. These changes are well underway all across the state. We are, of course, hopeful that the widespread vaccination of citizens will help put an end to this pandemic, but we're not there yet. And even when that day comes, our courts will face a huge challenge, one for which we will need your help. As I said before, we've gone essentially 1 year without jury trials. Although judges across the state have worked hard to keep the jail populations down, there still remains a large number of inmates still sitting in jail waiting for their cases to be heard. And although we now have lifted the suspension of jury trials, it could take up to 1 and possibly 3 years to dig out of this backlog. Not only will we have significantly more cases, but the process of moving those cases through the system, at least initially, will go more slowly due to the safety protocols. As we resume jury trials, if we're only able to move at a third of the pace, we will be relieving some of the pressure, but the backlog will continue to grow. Fulton County has the largest court system in this state. In a 10-month period, the number of defendants in jail without being indicted grew from 230 to roughly 1,400. At the same time, of the 40 courtrooms normally used in Fulton County for trial courts, only 2 are large enough to hold an array of prospective jurors while accounting for social distancing and public health precautions. Throughout the pandemic, we have suspended the statutory speedy trial deadlines as a part of our statewide judicial emergency. But once the governor ends the public health emergency, by law, the judicial emergency must also end. Under the Georgia statutory law, if a defendant files a speedy trial demand, the court has only a few terms of court to try that person. And if it fails to meet that deadline, the defendant is automatically acquitted and released. Fulton County and other large counties have terms of court that are only 2 months long. Imagine what would happen in Fulton County if those 1,400 inmates, when indicted, all filed speedy trial demands. The avalanche of demands would overwhelm the court system, and a sizable number of defendants would be acquitted and released without trial. We realize the burden of having defendants waiting longer for trial while being in jail. But we need to have a system that actually determines whether people who have been charged and indicted with a crime are guilty or innocent before allowing them to walk free. So we need your help to avert this crisis. We're also very grateful to the Georgia General Assembly for your support for Senate Bill 163, which is designed to address this situation. This legislation will allow trial courts in some counties to continue to suspend statutory speedy trial deadlines until those deadlines could reasonably be met. Constitutional speedy trial rights are not affected, and this legislation has a sunset date, so we're targeting this legislation to allow us to get through this backlog. This legislation is the highest priority of the Judicial Council and the Georgia courts, in Georgia Superior and state courts. And we have proposed other legislation that will help as well to get through the backlog. All these legislative proposals are supported by the Judicial Council, and we appreciate the amount of consideration that you have given them. I've mentioned to you before, our courts have had to pivot and change, like many businesses in our society. Probably the biggest change in how our courts operate today has come through the use of technology. And many of our judges have surprised even themselves by how proficient they have become. In every judicial order that I've signed, we have encouraged courts to switch from in-person court proceedings to video conferencing where legally and practicably possible. Many of our courts rose to the occasion and seem to have turned on a dime. As president of the Council of Superior Court Judges, Chief Judge Brian Amaro of Henry County pushed for the immediate acquisition of WebEx licenses so Superior Court judges around the state could increase their use of video conferencing. Today, 238 licenses are now in use by judges all over Georgia. Under Chief Judge Brasher, the Fulton County courts have built a huge infrastructure around Zoom with more than a dozen Zoom stations at the Fulton County Jail so that judges can conduct arraignments and plea hearings without having to transport defendants. Pre-COVID, the county was busing 200 inmates a day to the courthouse, involving an enormous security undertaking. Today, they transport an average of less than 12 a day. I believe that this is one of the types of changes that may become permanent. We have learned a great deal during this pandemic, and we need to continue using some of the things that we've learned to make us better and efficient. There are other types of hearings I believe that we will continue to conduct virtually. We have learned that it probably doesn't make sense to require an attorney from Savannah to travel to Atlanta for a 15-minute status conference with the judge, where the judge will simply ask, "How are we looking? When do you think we're going to be ready for trial?" The client really shouldn't have to pay for that. That could be easily conducted virtually. One of the many heroes during this pandemic has been Chief Judge Rob Leonard of the Cobb Judicial Circuit. As chair of the COVID-19 Task Force's Technology Committee, he has led the judiciary on technology matters and helped many of our judges become more savvy and capable. Judge Leonard took it upon himself to create a library of video tutorials to help judges learn how to do Zoom and other virtual proceedings. He's made use of technology understandable and accessible, and we are very grateful to him. I also want to mention a few more judges and thank them for their dedication and leadership and creativity. Newton County's probate court judge and Chief Magistrate Judge Melanie Bell, member of our COVID-19 task force, became sick with the virus early in the pandemic. So sick that she spent 4 days in the hospital. But she recovered and has since become a beacon of hope and vigilance for the judiciary, stressing that this crisis has brought Georgia's judges together in a collaboration like never before. After his son contracted COVID-19, Cobb County Superior Court Judge Tane Kell conducted virtual hearings from a makeshift courtroom in his bedroom, complete with an American flag. Under the leadership of Judge Dale Bubba Samuels of Monroe and Judge Willie Weaver of Albany, the Council of Municipal Court Judges early on developed best practices and guidelines for operating municipal courts to ensure the safety of the public and court staff coming into the courthouses. Chief Judge Norman Quadra of Suwannee has lost 3 family members to COVID, yet continues to stand out as a leader on the COVID-19 task force, working with interpreters and court reporters. Chief Judge Asha Jackson of the Cobb County Superior Court has been an innovative force on the COVID-19 task force and with the judiciary as a whole. She recognized early on the importance of improving ventilation in the courtrooms and made that a priority for change. This pandemic has had some unexpected consequences within the criminal justice system beyond how the courts are adapting. One of the effects of the pandemic has been an increase in mental health problems, drug abuse, and suicide, both among those who come before our courts and those who work within the judiciary. People with mental illness or substance abuse, or both, are already considered a vulnerable population. They have needs which are typically unmet and which are driven up, which drive up their risk for criminal activity or suicide. With the pandemic, many therapy and support group meetings have shut down, and this isolation and lack of interaction has contributed to their problems. Yet in Georgia, our accountability courts or specialty courts, dealing with drug courts, mental courts, and others, are thriving. The work of the professionals and judges in these courts has been unwavering throughout this past year. I've been amazed at their dedication and perseverance as they've stepped up to go the extra mile. Accountability court team members have maintained critical contact with program participants by visiting them at their homes, not only to confirm that they are staying away from drugs and alcohol, but also to ask how are they doing and whether they need anything. The courts have helped keep participants connected by setting up treatment groups who can meet virtually and by conducting Zoom status hearings with judges. These participants know that the judges and staff are invested in their lives because they meet with them virtually every week for a minimum of 18 months. Some judges have begun returning to in-person group therapy sessions using masks and alternative sites, including meeting outdoors when the weather has been good. Superior Court Judge Stephen Kelly of the Brunswick Judicial Circuit has been holding felony drug court in a gymnasium. Georgia now has 169 accountability courts. That's up from 72 in 2011. Chief Judge Kathleen Goslin of the Northeastern Judicial Circuit has been a solidifying voice as leader of the Council of Accountability Court Judges in continuing to further the development of Georgia's specialty courts. Even during a pandemic, 6 new accountability courts are preparing to begin operations in the next year. Georgia's accountability courts help fuel our economy. Each graduate has a positive economic impact of $22,129 based on the amount of money saved from avoiding sending that person to prison, as well as other avoided costs. If you take that $22,129 and apply it to the 1,841 participants who graduated last year, that's more than $40 million in positive economic impact to the state of Georgia. We appreciate the support that you give and continue to give to these courts. We've also realized during this past year the psychological impact the virus has had on the already stressful legal profession. In October of 2020, we lost an assistant district attorney in Columbus, Georgia, to suicide. I don't know what role COVID played in that, but a recent academic study supported the association between several COVID-related experiences and suicidal ideation and attempts. These findings underscored the need for access to mental health services during a pandemic. We know from research that connectedness to others has been identified as an important protective factor in preventing death by suicide. Throughout the pandemic, we in the legal community have been working to foster connectivity among its members and raise awareness of available services. In April 30 of this year, the Chief Justice's Commission on Professionalism, under the leadership of Ms. Carlise Greer, will hold a suicide awareness program statewide. We want to make the case that death by suicide is preventable. We want to assure members of our legal community that it is okay to ask for help. I began talking to you today about justice and the rule of law, and I wish to conclude on that topic. In this past year, our world has been rocked by a pandemic. My friend, Chief Judge Ben Studdard of the Henry County State Court, believes history will call 2020 the year of the pandemic. But he also believes that 2020 will go down as the year of the call for justice. I like to think that we are in a historic time of opportunity and reconciliation. I've often said that at bottom of the social unease we are experiencing is an insistence on the rule of law. That's what we are all asking for. That is the true promise of our judicial system. Both the pandemic and the social unrest of this past year call for an even greater fidelity to the rule of law, not less, but more. My friends, I believe that every growth spurt in our nation's history, moving us closer to the promise of liberty and justice for all, has come only after some degree of strife and turmoil. What gets us to the next level is when people of goodwill do the necessary soul searching and put on the shield and do the work that it takes. I believe that a year from now, when my successor delivers the next State of the Judiciary address in this hallowed hall, life will be different. We can only speculate about what will return to the way it was and what will not. But one thing I'm sure of, regardless of what will be in the wind on that day, Georgia's judiciary will remain steady and fully committed to the rule of law. That will not change. It has been one of my greatest privileges of my life to serve the last 16 years as a justice on the state's highest court. In preparation for my departure from the court on July 1, last week my colleagues voted unanimously to name Presiding Justice David Namias as your next Chief Justice. Justice Michael Boggs will succeed him as Presiding Justice. There are no two more able. Our state is extremely fortunate to have them in these roles. A reporter recently asked me what I will miss most when I step down from the bench. I did not hesitate. The people. My colleagues, our court staff, the judges I've gotten to know, and I'll miss you, the many legislators with whom I've worked over the years. It has been such an honor. Thank you for that honor. May God bless you, may God bless your families, and may God bless the state of Georgia.
At this time, I will ask the doorkeeper to escort the Supreme Court justices and their distinguished guests from the chamber. Members of the House, we have been honored to be joined today by some distinguished friends from across the hall. Please recognize and honor my dear friend and a former member of this body, the Lieutenant Governor of Georgia, Jeff Duncan. The President Pro Tem of the State Senate, the Honorable Butch Miller. The Speaker Pro Tem of this body, Speaker Pro Tem Jones. And the Majority Leader of the Senate, Majority Leader Dugan. And the Minority Leader, Minority Leader Butler. Thank you all very, very much. Chair recognizes now the Majority Leader of the House for a motion.
Mr. Speaker, I move that now that this joint session be dissolved.
The Majority Leader has moved that this joint session of the Georgia General Assembly be dissolved. All those in favor of the motion will say aye. Those opposed will say no. The ayes clearly have it, and this House, or this joint session is now dissolved.